Hello and welcome to this Housing Management Inbox webinar. My name's Gail Sykes. I'm partner and head of social housing at Buckles Solicitors, and I'd like to speak to you for the next 40 or 45 minutes about new developments in housing law. But I thought, just to make things interesting, rather than simply talk you through the new developments, it would be nice to have a look at some particular topics and to run through the law as it stands now and the new developments. This broadcast is actually being made without an audience due to previous technical issues, but at the end I will explain to you how to get questions to me or to the CIH if that's what you would like to do, and I'll happily answer those and ask the CIH maybe to put together a frequently asked questions list that can go out to all delegates to this webinar. So without further ado, let's start. The first subject that I thought would be worth looking at is the subject of non-succession. And as you'll probably realise over the years, succession and the right to succeed has become increasingly complex as an issue. And certainly it hits my desk fairly frequently as the housing shortages mean that more people challenge decisions that they're not to succeed to a tenancy. There are actually two new cases of interest in relation to this, but before I look at the new cases, I thought it would be worth recapping with you the law as it stands at present. So what about the entitlement to succeed then? If one of these cases hits your desk, what is the starting point? Well, I guess the starting point is something that most of you are well aware of, which is that generally speaking, there's one succession only, irrespective of whether that's a secure or an assured tenancy. And the death of a joint tenant counts as a succession, although in strict legal terms, it's not a succession, it's a function of joint tenancy law. However, what that does mean is that joint tenants can't have a second succession either, hence the reason it counts as a succession. You'll probably appreciate as well that secure and assured tenancy agreements can differ in relation to who they allow to succeed. And the key date in relation to this is the 1st of April 2012, being the commencement of the Localism Act 2011 and the relevant sections in that relating to succession. Just a very quick look at secure tenancies first, and just to remind you that pre-1st of April 2012, there is a wide list of successors set out in section 113 of the Housing Act 1985. And it's not possible for the landlord of secure tenants to change or amend that list. They are fixed with the list of would-be successors. And if that successor appears on the list and they fulfill the criteria in relation to residency, then they will be allowed to succeed. There's a case, Wandsworth and Michalak, dating back to 2002, which states in no uncertain terms that list can't be extended, but neither can it be shortened. So in brief, pre-1st of April 2012 secure tenancies allow succession by spouse or civil partner, provided that they've lived at the property at the date of death, or for that wide group of family members set out in section 113, provided that they've lived at the property as their only or principal home for a year prior to the death. Post 1st of April 2012, in relation to secure tenants, then the landlord has some more flexibility about who they allow to succeed. However, a lot of landlords have simply sleepwalked into this and haven't actually taken advantage of the fact that it's possible now to reduce would-be successors to spouse or civil partner. In short, post 1st of April 2012, if you have a secure tenancy, the only individuals allowed to succeed will be those listed in the tenancy agreement unless they are spouse or civil partner, so that if your tenancy agreement is dated 1st of April 2012 or later, then only those listed are going to be able to succeed, provided that they have fulfilled residency. What about assured tenancy agreements? Well, actually, the 1988 Housing Act only allows for succession by spouse or civil partner. It doesn't even allow for succession by those living together as spouse or civil partner. Pre-1st of April 2012 agreements often seek to expand that list of would-be successors by listing others who can succeed. And if you have a stock transfer organisation, many of those stock transfer tenancies will probably list the full list of individuals as set out in section 113 of the Housing Act 1985 who can succeed too. Bear in mind that if you have a 1st of April 2012 tenancy, and this is an assured tenancy, Unless the individual succeeding is spouse or civil partner, it will be a contractual succession, and it's necessary to set up a new tenancy agreement if you allow that succession to go forward. Post 1st of April 2012, same rules apply. Spouse, civil partner, and those listed in the tenancy agreement are entitled to succeed. The difference is that the tenancy automatically vests, that is to say, transfers itself to the would-be successor, and there is no need to set up a new tenancy for those individuals, i.e. those other than spouse or civil partner who previously had contractual rights. Bear in mind when you're looking at succession and whether the claim is going to be successful or not, where there is a requirement for residency of a year, that needs to be residency as principal or only home, and there needs to be a real intention to occupy as such for the whole period of a year. Case of Islington and Freeman is the leading case in that, and in which the Court of Appeal said, well, Miss Freeman had actually occupied her father's property for some of the previous 12 months as her only or principal home, but not all of it, and therefore her succession claim failed. So if you come to the conclusion that there is no succession, what's the procedure? Well, serving notice to quit on the personal representatives of the late tenant and the public trustee is a must. And that's the case even though many of your tenants probably won't have a personal representative, that's to say an executor or somebody holding letters of administration. I'll come back to service on the public trustee later because there's been an interesting case on that point. Once the notice to quit expires, the tenancy comes to an end. You're serving a notice to quit because secure or assured tenancy status fell away on the death of the tenant. So Section 83 or Section 8 notices are not appropriate in these circumstances. Issue the claim against the personal representatives and the non-successor occupier if there is one, and assure that first of all you've actually fulfilled the requirements of Part 3 of the Possession Claim Protocol in relation to non-successors. You'll appreciate that Part 3 talks about mandatory possession grounds, and notice to quit is a mandatory possession ground, and also specifically lists non-successors as individuals to whom you have to, at the very least, write to ask them to set out to you their personal circumstances and the reasons why it may not be proportionate to evict them. And also, always avoid your policy to avoid challenges. Recent case suggests that this is particularly important, and we can look at that case now. It's not changing slides. Okay, apologies for that, brief technical issue with the slides, but we're continuing on to my second slide and the case of Haringey and Samawi. So what we're looking at here is a situation where Mr. Samawi's mother succeeded to a secure tenancy which had originally been granted in the sole name of her husband, Mr. Samawi also being the appellant's father in this particular case. Mr. Samawi's mother died in 2013, and at that point he applied to have the tenancy transferred to him, stating that he'd lived at the property for more than 10 years. Of course, there'd already been a succession or a deemed succession at the point that Mr. Samawi, the sole tenant, and the appellant's father had died. And the local authority quite rightly said that under statutory regimes, there was no second succession. Accordingly, they served a notice to quit and sought to end the tenancy and to evict Mr. Samawi Jr. Mr. Samawi defended those proceedings on two grounds. First of all, he said Haringey had failed to follow its own policy on non-statutory successions. That is to say that their policy allowed them a discretion to grant a second succession. And secondly, that the prohibition on second successions was actually discriminatory to someone whose parents had died. In particular, he said, had his parents divorced and an order been made under divorce proceedings that his father, Mr. Samawi, should pass the property to his mother within those divorce proceedings, then that wouldn't have affected his entitlement to succeed because those proceedings wouldn't have been deemed as a succession. So an interesting legal point. In fact, Mr. Samawi's defence succeeded insofar as the court had found that the local authority had not followed its own policy. So a note here to always make sure that you have followed your own policy, and if there is a discretionary succession policy in place, to make sure that that is considered and followed too. The High Court rejected Mr. Samawi's argument that there was a difference in treatment that caused some sort of issues in relation to human rights because his parents had died rather than divorced. They simply said that this was not because of any personal characteristic or status, but because of the legal mechanism under which his mother had succeeded to the tenancy. It was thought that that would be an end to the matter, but this has now been appealed to the Court of Appeal, and the Court of Appeal has granted permission to appeal on grounds that statutory succession scheme could be incompatible with right to family life and a home, together with various other technical issues. And that appeal is listed for hearing in the Court of Appeal during October 2019. As a note, if you have any cases at the moment which have been stayed, pending the High Court decision in Mr. Samawi's case, and which maybe have been unstayed following the High Court's decision that there were no human rights issues to consider here, then unfortunately they will probably be stayed again pending the Court of Appeal's decision. Second case to look at in relation to non-successions, a recent and probably quite problematic case is that of Pavey and Hackney 2017 case. Again, what we have here is a case of non-succession. We have Hackney serving a notice to quit on the personal representatives of the deceased tenant, and also, of course, serving a copy on the public trustee. The problem was that Hackney served their notice to quit on the personal representatives and then many months later served on the public trustee before issuing possession proceedings. Hackney relied on a saving clause in their notice to quit, and you'll probably appreciate a saving clause is that clause that says if I have the date wrong in my notice to quit, then it will become effective on the first possible date that is correct. And the district judge found that the saving clause was triggered at the point that service on the public trustee had been effected, so the later service on the public trustee, and therefore that the notice to quit had brought the tenancy to an end and that Hackney were entitled to possession against Mr. Pavey. Mr. Pavey appealed that decision, and the decision came before His Honour Jan Luber QC, who's now sitting as a circuit judge in the Central London County Court. Now, bear in mind this is a circuit judge decision and not strictly speaking binding, but it is persuasive, and because Jan Luber is one of the leading housing law barristers, or was one of the leading housing law barristers, and is now a housing law centric judge in the court in London, it is certainly a very persuasive argument, and it will take a lot to overturn this unless and until somebody appeals above circuit judge level. What Jan Luber found was the public trustee was the notional tenant of the property, and the notice was actually invalid or void for uncertainty, as the dates of termination of the tenancy differed considerably in relation to that served on the personal representatives, given that it was served so many months afterwards. Accordingly, Hackney's claim for possession was doomed to failure. So make sure that when you're serving your notice on the personal representatives, you also serve on the public trustee, and you'll be aware that to do that you need to send off the notice with form NL1 from the public trustee's office and a cheque for £40. Make sure you allow time for postage, and that both notices can expire on the same time and will not expire on different dates because one is served later than the other. This is an argument which is now being raised in many existing non-successor possession cases. Moving on to the next subject I wanted to consider, just having a look at a possession claim, and in particular a couple of new cases, but the things you need to consider when actually issuing a possession claim, and probably before you ever get to the point of serving court papers on your tenant. The first thing that seems to go wrong quite frequently at the moment is a failure to consider at an early stage whether the tenant actually has capacity in court proceedings at all. And by capacity in court proceedings, I mean the ability to understand the basics of those proceedings and to retain information and to give fairly simple instructions to their lawyer in relation to the court proceedings which are underway. Bear in mind that Part 3 of the Possession Claim Protocol requires you as a landlord to consider whether capacity may be an issue at a very early stage and to let the court know at the first possible opportunity, so the first hearing, if it's unlikely that the defendant has capacity. And the way I would do that is to serve at court before the hearing a witness statement setting out why you believe capacity isn't in existence here, and why, under Part 21 of the Civil Procedure Rules, those rules that govern the court, a litigation friend should be appointed to actually run the proceedings on behalf of the defendant tenant. Bear in mind, if you're taking that route, that the court needs to make a very specific finding in the order that it makes, that it believes that the tenant lacks capacity, or found that the tenant lacks capacity, and that a litigation friend needs to be appointed. In default of anybody coming forward to act as litigation friend, the official solicitor will act, but bear in mind that causes considerable delays. So it may be worth at a very early stage considering whether friends or family could act in that capacity and are suitable to act in that capacity, and whether they will sign something called a certificate of suitability confirming that they will do so. Otherwise, you're potentially in for a long haul anyway. Second thing to consider, especially if you're bringing possession under mandatory grounds, is whether you've reviewed, in accordance with your procedures and also the possession claim protocols, the proportionality of that decision to bring the claim. And although this started to be an issue specifically for mandatory grounds, it has leaked out, if you like, into discretionary grounds for possession, so rent arrears cases, and also antisocial behaviour and breach of tenancy cases. So I would say in all cases, very much consider whether or not you need to undertake an impact assessment and whether or not the decision to move forward is proportionate. Also, if you are relying on mandatory grounds, does your policy and does the tenancy agreement allow for use of mandatory grounds? Some old tenancies, especially stock transfer ones, set out specific grounds upon which the landlord will rely, and if those new, for example, ASB mandatory grounds as introduced by the ASB Crime and Policing Act aren't actually listed in your tenancy agreement, there is a strong argument that you should not be allowed to rely on them. Similarly, I hope your policy has by now been updated, but if your policy doesn't list those as grounds upon which you intend to rely, that can also cause issues. Look at contractual notice provisions. Again, a lot of stock transfer tenancies, but also some others, still require contractually 1 month's notice of seeking possession, even if, for example, you're relying on ground 2, the discretionary ground for possession on ASB, or ground 14, the equivalent ground under assured tenancies. If your tenancy agreement says you need to give 28 days, even though the statutory regime says that you can serve your notice and issue immediately, then you should be giving 28 days, unless there's very, very good reason not to. But I would seek legal advice on that point. I spoke a little when it came to considering possession claim protocol and review procedures about the possibility of an impact assessment. The impact assessment really is designed to cover off 2 defences which are often raised by tenants in possession proceedings. First of those defences being under the Human Rights Act, although that is now a little bit of an uphill battle for a tenant, but the second being a defence under the Equality Act 2010. That is to say that the tenant is disabled under the Act and that there is a link between that disability and the reason you are seeking possession. Leading case in that is Ackerman Livingston versus Astor Communities Limited, and if you haven't reviewed or read that, it is well worth a read. But I would say now, if there's any suggestion at all that you have a disabled tenant, whether that is physical or mental disability, undertake an impact assessment before serving a notice and certainly before issuing proceedings. And also bear in mind that impact assessments are living things, and if things develop during the course of possession proceedings, you may need to revisit that impact assessment and update it. And finally, again, make sure all relevant policies and procedures have been followed. If not, can you justify the departure from those policies and procedures? Which moves me neatly on to the first recent case I want to look at, the case of Ahern and Southern Housing Group Limited. In this case, Mr. Ahern occupied under a starter tenancy, so a probationary tenancy, which had already been extended for 6 months as a result of serious antisocial behaviour. It was common ground that he was an alcoholic, and it was also common ground that the ASB continued after the starter tenancy had been extended and at the point at which Southern served a Section 21 notice. The district judge found that Section 21 notice had been correctly served and made a possession order based on that Section 21 notice, although at the time Mr. Ahern had been on police bail and under the conditions of his bail couldn't return to his flat, which did mean that Southern Housing Group could not in fact contact him to, for example, offer any further support or assistance in relation to his behaviour. Mr. Ahern appealed the decision making the possession order. He claimed that Southern had failed to follow their own policy in identifying his support needs and also in relation to his vulnerability. So this is really a case of the decision is not proportionate based on the fact that you have failed to actually support me and follow your own procedures. Matter went to the Court of Appeal, which upheld the possession order in quite a helpful case. And what the court found was that both parties had agreed that Southern was obliged to follow its own policies unless it could show good reason not to. The court found that on the facts, Southern had signposted Mr. Ahern to alcohol treatment programs, and that they had also become aware that this was not working and that he continued to drink, and that Southern were also aware that mental health services were involved, but issues had continued. The court found that the ASB was serious and included threats to kill, harassment, and also homophobic comments, and that Southern had considered the impact of the possession order on Mr. Ahern. So very much an impact assessment taking place here. So quite an important key to the decision, I think. The court found that given that Mr. Ahern couldn't be found, the landlord could not be obliged to continue to signpost support. And accordingly, although it was common ground that policies needed to be followed unless there was a good reason not to, in this case, it wasn't possible for Southern to adhere word to word for their policy because of Mr. Ahern's absence, and the approach when a court considers cases such as this should very much be whether or not the purpose of the policy or procedure had been followed and whether a pragmatic approach had been taken. So quite helpful if you can't follow your policies or procedures in full to fall back on Ahern, provided that you have a good reason not to follow those policies. Second case I want to take a very quick look at in relation to possession proceedings was that of Harris and Hounslow. Really quite a niche case for secure tenancies, but quite interesting, I think, given that there was a lot of debate at the point at which the new mandatory possession grounds for antisocial behaviour are introduced about whether or not giving tenants 7 days to request a review in writing under Section 85ZA of the Housing Act 1985 was adequate. 7 days given being a very short period of time for the tenant to actually request to appeal. In this particular case, Hounslow sought to terminate Mr. Harris's tenancy under mandatory ASB grounds following the making of a closure order, and you'll remember that that is one of the grounds under which those mandatory possession orders can be made. Hounslow didn't respond to a request from Mr. Harris's lawyers to be given longer than 7 days to actually seek a review. They did, however, hold a review, and upheld the decision to seek eviction. And Mr. Harris appealed that decision. Interestingly, the Court of Appeal found that the time for seeking the review had actually been enshrined in Section 85ZA, and the authority had no power to extend it and no obligation to undertake a review if no request in writing within the 7 days had been made. So although 7 days seems fairly mean and a fairly tight timescale for tenants, bear in mind that there is no obligation on you to actually extend that any further. Third area I'd just like to have a look at as being something quite topical at the moment is the area of the hoarder. And really just to highlight a few points to you if one of these lands on your desk. That is to say, a case, not the hoarder. Disability issues can arise out of this, and I think it's now common ground that a lot of hoarders do in fact have mental health issues of some kind, and possibly some hoarding or property condition cases can also be linked to physical disabilities. So the first thing to say about this is that in common with any other possession proceedings, before you take matters too much further, if you're considering issuing proceedings, whether that's injunction proceedings or possession proceedings, it's probably quite important to undertake an impact assessment. The second point, which is always a really interesting one when dealing with cases like this, is which route to follow. Do you follow the injunction route? So seek a court order with a penal notice attached that unless the property is cleared up, then you may take proceedings to take the hoarder to court to have them sent to prison or fined, or do you go straight for possession? And what I would say to that is it needs to be considered very much on a case-by-case basis. There may be some cases in which an injunction will never work simply because the individual concerned can't physically or mentally comply with that injunction, in which case it's clearly not appropriate to seek an injunction, and under those circumstances it would be highly unlikely if you would succeed in any committal proceedings on the back of that. Provided that you've covered that off and you've decided that an injunction is inappropriate, then that really leaves you with very little option than to hop straight to possession proceedings, seeking perhaps a suspended possession order in which, with help, the hoarder can resolve the issues with the property. However, there are some cases in which injunctions may work, specifically if you need access or you need the individual concerned to engage. I think it's always very important when you're dealing with cases like this to use an objective test. It's no good to subjectively say the property is a mess. And the objective test that I would suggest you use is the clutter rating index. If you haven't come across that index, quite easy to find on the internet if you key those words in, and the internet will bring up a number of photographs rated from about 1 to 9 of various rooms in a property, illustrating how bad the clutter is. And I would normally say that once we're up to clutter rating 4, then there is probably a case to say it is worth going to court. But of course, it's possible to use that clutter rating index, for example, when setting out a notice of seeking possession, or dealing with a witness statement, or setting out particulars of claim, to actually set out objectively to the court the level of clutter involved in a particular property. Of course, a picture always speaks louder than words in these cases, and if you are obtaining access and you can take photographs, then it's quite important to use those as well. And I wouldn't hesitate to actually attach those photographs both to the notice of seeking possession and also to the particulars of claim to set out and show exactly what the problem is. Fire safety is also a very good key point to make in these cases, and I would say before issuing injunction or possession proceedings, if a fire safety officer is willing to report that there are fire issues with the property, either in relation to the tenant's tenancy and their own safety, or also in relation to neighbouring occupiers, then vital and important evidence to get before you take too much further. And also consider at the end of the day what you want to achieve out of this. Suspended orders, injunction orders are all very well, but they need to be enforced. And I would say when those orders are drafted, they also need to be drafted objectively and in relation to the clutter rating index. So setting out various steps and timescales by which clutter should be reduced at the property. No case law here, but I thought it might be worth putting in a couple of case studies. For first case study, a matter I dealt with about a year ago involving an elderly couple, both diagnosed with physical health issues, so actually physically sorting out a huge hoarding problem. Property hoarded 8 to 9 on the clutter rating scale throughout was very difficult for them, but there were fire safety risks, as all exits had really been effectively blocked for easy escape in the case of a fire. And of course, given physical health issues, that's particularly problematic. Lots of interventions and offers of assistance were logged. They were also set out in an impact assessment, together with the fact that they had failed. An injunction was obtained initially, even though I think my client always knew that they were unlikely to commit the individuals to court for breach of that injunction. They felt the need to say that they had tried everything before they tried possession, given the age and the vulnerability of the individuals concerned. And we went to court as a last resort, having served a notice of seeking possession with photos attached, and also in relation to the clutter rating scale. Eventually, we actually got round the table with the elderly couple's solicitors, and a suspended possession order was agreed prior to trial to include both weekly access and improvements in relation to the clutter rating scale. Second case study, slightly different. Elderly man in a block of flats. Again, property very heavily hoarded to clutter rating 9. And just to add to the dangers involved, electric cables, the old Bakelite type, daisy chained over combustible clutter. The tenant from day one was very aggressive and uncooperative with staff. And as a result of that, we were able to say that we thought an injunction just simply wouldn't be appropriate, it wouldn't work, and possession was sought immediately due to the fire risk, not only to the tenant but also to others in the block of flats. Outright possession was actually obtained in this case, perhaps quite unusual given the vulnerability of the elderly man concerned. But by the time this matter got to court, and given the elderly gentleman's conduct during the court proceedings, the court found that the tenant was unlikely to comply with the suspended possession order and was, quite frankly, unmanageable as a tenant. I've been asked to touch on disrepair claims in this session because they do arise from time to time, and they can cause problems if you don't have a starting point to deal with them. So first thing to say is, I suppose, that there are two ways in which a disrepair claim can hit your desk. They can arise via a pre-action letter from the tenant themselves, or perhaps more frequently these days, a claims farmer who's been knocking on doors asking tenants whether they have any disrepair to their property. Or they can arise as a counterclaim in rent possession proceedings. So you've issued your rent possession proceedings, and the tenant or a legal representative on their behalf turns up at court and suggests that there is a valid defence to those rent arrears based upon the condition of the property. Bear in mind when looking at these cases that a landlord has limited liability in relation for disrepair, but there are certain things which will always be required from the landlord in relation to the repair of the property. And those minimum obligations are set out in Section 11 of the Landlord and Tenant Act 1985. And even if your tenancy doesn't reference Section 11 or set out the relevant parts of Section 11, they will be implied into the tenancy agreement in any case. In short, landlord under Section 11 required to deal with the structure of the property, those items that allow for heating and hot water and water generally to the property, are all things that the landlord simply can't escape from as an obligation. The landlord may also be liable under the Defective Premises Act, in particular if the premises are for some reason just unfit because of the manner of their construction or something that's happened at the property to make it deteriorate. And in relation to that in particular, but disrepair claims in general, always worth bearing in mind the case of Hannon and Hillingdon Homes Limited, which talks about notice. You'll probably appreciate that a landlord can't be responsible for any repair at all unless they are aware that the repair needs doing. More often than not, repairs, applications, inquiries will come through to your offices, and will be logged and dealt with there. And clearly that is express and explicit in relation to you knowing about the repairs requiring immediate attention or attention generally. Very important to have a robust system in relation to that, since if these disrepair claims do come in, it's important to be able to say that your recording system will pick up those express telephone calls, letters, and that none of those are likely to fall through the net. The bigger problem tends to arise with constructive notice, that is to say, situations where the tenant hasn't actually advised that the repair needs undertaking, but in which you are found to have known about it in any event. So to give you an example of this, in the case of Hannon and Hillingdon, we have the tenant removing the banister rail from the property. One of Hillingdon's contractors going to the property to deal with heating problems, coming flying down the stairs to try and do that and falling over the edge and breaking a bone in his leg. He then sues Hillingdon on the basis of the Defective Premises Act and the fact that they should have known that the tenant had removed the banister. Why should they have known? Well, some of their staff had been to the property and should have seen or noted the disrepair. And some contractors had also been to the property, and the court found that they also were in a position to note the repair. So it's a case of being vigilant as you travel around, undertake your visits. If the court finds that you should have seen something even though it wasn't reported to you, then potentially you are stuck with constructive notice. If the claim arises from a pre-action letter, that is to say not in court proceedings as a counterclaim, always very important to respond within timescales. If you don't respond within the timescales, then potentially you have costs issues and could be criticised by the court. That letter may suggest a joint inspection by a joint expert, but I would say it's never really very sensible to agree to the expert suggested by the sender of the letter, because their experts are likely to be tenant biased surveyors who are doing numerous reports for the same lawyer. And although they shouldn't be biased and shouldn't be biased towards the court, I would always find another party for whom you're happier to have a joint inspection. Keep in mind that certain repairs may not be your responsibility at all. We've talked about the things that are, but what often creeps into these claims is a question of damp. Damp will only be your responsibility if it arises as a result of disrepair, something you should have fixed, for example, a leaky gutter, or a defect in the property, and not as a result of the tenant's lifestyle. So condensation caused by drying, washing, etc. should not be your responsibility. In the event that you do find that you're at fault, and it's quite important to find that out and inspect fairly quickly, press to put it right very quickly and seek swift resolution. First of all, because if you don't, you may be hit with an injunction requiring you to do so and the costs involved in that. But also, the longer these things go on for, the more you will be required to pay in relation to what are often inflated costs from the claims farmer. And whatever the claims farmer seeks from you, it's also always worth negotiating in relation to those costs. Similarly, claims farmer will often, if you are in the wrong, suggest settlement on the basis of inflated compensation. And I would say always seek advice before settlement. You should never actually accept the first offer in that regard. What about disrepair claims arising without warning at a rent possession hearing? And I often hear that rent officers are hit by this when they go to court. It comes as a bit of a surprise. First thing to say is don't panic. It will be necessary to agree directions, so those orders made by the court to take this matter to a longer and more detailed hearing. But I would say always avoid a huge list of directions by which you end up at trial. I would say to start with, limit those directions to a defence and counterclaim being filed so that you can check exactly what's being said and the validity of the claim. And then have another hearing at which further directions to take the matter to trial can be made if appropriate, and if it's not appropriate for you to settle. In the meantime, I would always suggest adjourning on terms. The other side will also say, well, let's just adjourn this pending directions taking place. Adjourn on terms of current rent together with an amount towards the arrears. The chances are that amount towards the arrears, or perhaps even the rent, won't be paid, but it does set down a marker and allow you to bring the matter back to court if you need to in the meantime. And use the time involved whilst the other side are claiming via a defence and counterclaim to check whether you were in fact on notice, whether you did know of any alleged defects, and whether in fact the defects exist at all. And finally, and perhaps one of the most interesting sort of developments during recent months and the last couple of years, has been the difficulties which are now arising in terminating assured shorthold tenancies using Section 21 notices. So this is of particular interest to you if you're using starter tenancies, or if you're using ASTs, for example, for intermediate rent cases. The most recent case has made it particularly difficult for landlords in relation to the requirement to serve gas certificates. And under the Regulation 2 of the Assured Shorthold Tenancy Notices and Prescribed Requirements England Regulations 2015, it's necessary for a social landlord to serve both a gas certificate and EPC on the tenant, preferably before occupation or the tenancy commences. But having said that, it had always been thought that it was possible to rectify that if that hadn't happened by serving the gas certificate and EPC just prior to the Section 21 notice being served. As we'll see in a minute, although it is probably still possible to rectify failure to serve an EPC before occupation, the gas certificate is far more problematic. What else do we need to know about Section 21? Well, if you're relying on Section 21, also very important to look at proportionality issues, impact assess, and look at Part 3 of the Possession Claims Protocol as a minimum before you ever serve your notice or issue proceedings based on it. And make sure in relation to the Section 21 you allow clear 2 months notice, so allow for service by post or by hand. Bear in mind, if you're serving a notice on the way home from work one day, for example, it's unlikely to be deemed served until the next working day. And also, although it won't affect many of you, if you have deposits in place, and I know some intermediate rent providers maybe have deposits, they will have needed to be protected in one of the government schemes, and the statutory information provided within 30 days of receipt. I've said that the gas certificates are causing particular problems at the moment, so just really want to run you through the case of Carridon Property Limited and Monty Schultz. You'll see this is another Jan Luber QC case, again sitting as a circuit judge in the Central London County Court, this time in an appeal from a decision by a district judge to grant possession under 21, following a discussion about when gas safety certificates should be served. Again, bear in mind that this case isn't binding because this is the circuit judge's decision, but it is persuasive and it is causing lots of problems around the country at the moment. Certainly I have a lot of defences being amended for tenants who are defending claims against my landlords based on this case. So in this case, gas safety certificate wasn't served before the tenancy agreement started, but as we had always thought, that had been rectified, or we thought it had been rectified, by serving before the service of the Section 21 notice. So gas certificate EPC served shortly before the Section 21 notice, but not prior to occupation. His Honour Jan Luber found on appeal that a failure to serve the certificate before the tenancy started couldn't be remedied, and the landlord couldn't rely on the Section 21. So unfortunately, unless you serve the gas certificate prior to the occupation of the tenant or the tenancy agreement starting, then you can't put it right by serving that gas certificate at a later date. As I said, defences now very much reflect this. We can actually take this one step further, and I've had quite an interesting case earlier this year in relation to a block of flats. Two scenarios arise with flats. First of all, where you've got a boiler serving the whole block of flats within the block, necessary to ensure that the gas certificate is actually displayed in the block itself, together with a notice to say how the tenant can get a copy of that gas certificate, or failing that, is given a copy of the gas certificate before their tenancy starts. And I think it goes without saying with all of this that you need something signed by the tenant to say they've had these documents, otherwise you're going to be hit with these sorts of arguments anyway. The case that I had actually involved a gas boiler which was remotely situated in a boiler block outside of the block of flats itself. And the argument was still raised that my client should have served or should have displayed a copy of the gas certificate, even though that gas boiler was in a different building. Now, unfortunately, my client decided not to take the risk of running that to an appeal hearing, which is a shame, but also bear in mind the fact that gas supply apparently is totally outside the block, and the boiler is totally outside the block, may not get you off the hook with the requirement to serve the gas certificate. That's all I have to say. Normally at this stage we would ask for questions, but of course I'm aware that actually there's no one out there at the moment. So if you would like to contact me, you will find my details on this slide. I'm more than happy for you to email, is probably the easiest, any questions you have on anything we've been talking about today. Otherwise, I'm aware that if you want to contact the Chartered Institute of Housing, and in particular Sarah Smith at the Chartered Institute in relation to that, they will be passing questions on to me, and we will try to gather those together and get the answers out to all of you as well as to you individually. Thank you very much.